allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You may be seated. I now call the scheduled meeting of the Board of Adjustments to order. Would Mr. Boney from the Planning and Development Office please describe the function and operation of the Board of Adjustments to our applicants and the audience?
Yes, Mr. Chairman. The Board of Adjustment is a quasi-judicial body established by the Board of County Commissioners under Chapter 62, Article 2, Division 4 of Brevard County Code. The Board of Adjustment is empowered to hear requests for variances to the zoning regulation and the sign regulation in Chapter 62, Article 6, and Article 9. Pursuant to Florida Rules of Appellate Procedure, any person or persons jointly or severally aggrieved by any decision of the Board of Adjustment may within 30 days after the date the order is signed apply to a court of competent jurisdiction for appropriate relief. Mr. Chairman, you have 4 items on your agenda today.
Thank you, sir. Would Mr. Huffman please explain to the applicants and the audience the definition of a hardship?
Thank you, Mr. Chairman. A variance may be definition of an undue hardship. A variance may be granted when it is not contrary to the public interest and where owing to special conditions, a literal enforcement of the provisions of this chapter will result in unnecessary and undue hardship. The term undue hardship has a specific legal definition in this context and essentially means that without the requested variance, the applicant will have no reasonable use of the subject property under existing development regulations. Personal medical reasons shall not be considered as grounds for establishing undue hardship, sufficient to qualify an applicant for a variance. Economic reasons may be considered only in instances where the landowner cannot yield a reasonable use and/or reasonable return under the existing land development regulations. The applicant must answer a hardship worksheet with 6 questions. The Board of Adjustment will discuss these questions today with each applicant who has requested a variance.
Thank you, sir. I'd like to address our board members, the applicants, and our audience for a moment. The Board of Adjustments is a quasi-judicial board with members appointed by the Brevard County Board of Commissioners. We'll utilize Robert's Rules of Order to conduct this meeting. The chair is asking all board members not to ask questions while the applicants are making their presentations. Once the applicants have completed their presentations, we'll begin board questioning with the board member who represents the applicant's district. When concluded, questioning is open to the full board. The chair will recognize each board member wishing to ask questions. Once all board members have completed their questioning, we'll then open it to the audience who may be here to speak concerning the applicant's application. Anyone from the audience wishing to speak will be given the opportunity to address the board, but only once. At the conclusion of public comment, the applicant will be given additional time for rebuttal, as well as to present any final comments. Once completed, no further comments will be heard from the applicant or the public. We will not use a timer for this meeting. Instead, we're asking each speaker to be concise in what they have to say. It is important that you stay on subject and avoid information that is not relevant. All persons speaking must provide their name and address for the public record. Those wishing not to verbally state their address may ask the clerk at the podium for an address card. Please fill it out and return it to the clerk. Are there any questions from the board member about the chair procedures? Any questions from the applicants about the chair procedures? Any questions from the audience about the chair procedures? Seeing none, our first order of business is to approve the minutes from the previous meeting. Are there any corrections or additions? Do we have a motion?
I'll move to approve the minutes.
A second.
Mr. McCann has moved to approve the minutes. Mr. Huffman has seconded. All in favor say aye.
Aye.
Any opposed? And our minutes have been approved. Mr. Bodie, may we please have the first applicant that is requesting a variance?
Yes, item number 1, variance application 22V00023, Triangle Auto and Tire Service, Inc. Request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-1482, 5A2, to permit a variance of 1.8 feet from the required 25-foot front setback for an existing structure, variance number 2, section 62-1482, 5A2, to permit a variance of 16.7 feet from the required 25-foot front setback for a proposed structure, and variance number 3, section 62-1482, 5A4B, to permit a variance of 4.4 feet from the required 5-foot side east setback for a proposed structure in a BU1 general retail commercial zoning classification, and this is located at tax account number 2437357 in District 2.
Very well. Will the applicant please come to the podium? And you can feel free when your case is before us just to go ahead and head to the podium. That'd be fine, okay? Hello. Please state your name and address for the record.
My name, excuse me, is Craig Dixon. I am his builder, Dixon Builders. My address is 11 Ohio Street, Cocoa, Florida.
Sir?
I am Louis Lorena, president of Triangle Auto. My address is 1422 Victoria Boulevard, Rockledge.
All right. Please raise your right hands, gentlemen. Do you swear and or affirm that the evidence you're about to give this Board of Adjustments is the truth?
Yes.
And speaking one at a time, please speak into the microphone. How may I help you? Please move closer to the microphone or move the microphone to you.
Louis had contacted us about, he has an existing roof and a concrete slab that's been there for some amount of years. He wanted to enclose it. We had drawings made and we submitted them for permitting, and they got stopped because of setback. And so we came and talked to Paul Bodie about it, and he said, we're going to need a variance if we are to enclose this. And one of the main drawbacks is his property's a triangle. And as you travel away from the rear of the property, it gets smaller and smaller and smaller. And what we want to do is, he needs this space, obviously, because his business is doing very well there on the corner. And he keeps his place up very nice. This roof, I don't know how long it's been up there, but it's been there for a while, along with an elevated concrete slab to match the existing foundation of the main building. And all we really wanted to do at that point was enclose it. If we get this variance, I think we're going to do a nicer job than what we had originally intended. It had a metal roof on it. I think we're going to do a nice looking structure since we've gone this far, if we make it past this. Louis, do you have anything to add?
Yeah, I mean, all we're trying to do is, basically the building was made in 72, so it's a smaller interior. All my lifts are inside. I have one existing lift that is outside on that slab that when storms come, it gets weathered and damages. The lifts break and all that stuff from being outside. So we're just trying to enclose the pre-existing lift for protection of the lift, and also install larger equipment because trucks are just so big now and heavy. I don't have the ability to lift them up inside the property anymore. They're hitting walls, or they're too long, or they're sticking out. So I'm trying to just beef up that area, get a little bit more heavy equipment to where I could pick up, the newer vehicles that are weighing twice as, they were when the building was made.
Okay. You're in District 2. That would take us to Mr. McCann.
Good afternoon. Good afternoon. The proposed garage, well, I think let's break your application down. You have 3 variance requests. The first one is to legitimize an existing structure by approving 1.8 feet from a required 25-foot front setback. That is the main garage building. Is that what that's referring to?
Well, I'm confused. Paul might have to help us here. 25-foot setback from
This is the way that we wrote it up, is that the existing building had a variance to it, applied to it, and it was to extend the back toward the east. Well, they never legitimized the front setback to the existing building. It's supposed to be 25, it's at 23.2. So we looked at it and said that needs to be legitimized since it doesn't meet the 25-foot setback. That's to the existing building. And then they have a proposed garage that they're putting on to the north, which is 8.3 feet, which requires a second variance to the front setback. So we're really trying to clean up some of the work that never got approved in the previous variance to the addition setback to the east.
You said there was a previous variance that was approved for?
Yes, there's a previous variance that was approved. It was, give me 1 second. It's variance V 572. This was granted to do an addition up to the east property line, which they did. That's the reason it's right up against the property line. And this was done in (1976), July of 1976.
Is that the third variance that we're looking at here, or no?
Pardon?
Is that the third variance that we're looking at here?
The third
4.4
variance is
from
trying
5
to
feet.
follow that variance
That
that
same
was
line.
approved is what it
Okay.
is. Yes.
Okay. So your proposed structure, the rear of your proposed structure will line up with the rear of the current
The existing
building,
structure, correct.
which has the variance.
Correct.
Okay. And then we're looking at a 1.8 variance request for a 25-foot front setback for the existing building. And I'm looking at the survey, and what Mr. Brody said, it's existing 23.2 feet from the property line. It needs to be 25 foot. So that's the 1.5 foot variance request, right?
Right.
Yeah, that's,
Okay. So, and then, so the second variance request, number 2, is for the distance from the proposed garage to the property line. That proposed garage to the property line only has a distance of 8.3 feet. So you need a variance of 16.7 feet to accommodate that proposed structure.
Correct.
Have you had an opportunity, there's a, in the lanes of travel on that's North Banana River Drive, right? The lanes of travel, there's a shoulder there.
Yes.
Is that correct?
Yes.
Have you had an opportunity to measure the shoulder?
Whatever that says.
yeah, and this is the edge of the roadway here, not here.
I think he's asking the distance, you'd asking for the distance of the structure to the
Edge of the roadway?
To the edge of the roadway?
Well, I know that structure is 8.3 feet, but then there's a shoulder then from
I
the property
don't-
line to the lanes of travel.
That's what we had to
That
get.
would have to be
That
at
was-
least 20 feet, something, if I don't have it here.
It's a pretty good distance.
Yes, sir.
Additional before the.
Right, you
actual
have the road and
Okay.
probably 15 of 20 feet of shoulder before my property starts.
So I'm just, in my mind, I'm trying to, you're going to the property line, but there's still another buffer. for
Correct,
shoulder.
there's a-
20 plus to the white line, the edge of the white line on the road.
Okay. I don't have any more questions.
Okay, thank you.
Ms. Mallard? No questions. Dr. Bass? No questions. Sir? Just a couple. The roof line's already there, correct? You're going to change it, but the roof line's already there, am I correct?
Yes, there is a roof line there. We're thinking about changing the roof. It is a metal
Right,
foam
right,
fill.
but you're enclosing into that same area that's already in
Yes.
existence.
Yeah.
Correct.
That's what I'm
So
saying.
basically, the building ends here. There's an opened cement slab that is there, that has a lift on it that's damaged.
Right.
We're trying to enclose the existing area that's already there and then just go a little farther to maybe have a secondary.
So the roof line that you're needing the variance on already exists, am I correct?
Yes, there's a,
Yes.
yeah, there's a roof, the
Yeah.
whole roof of the
Okay.
building is there.
So my other question, did you build this structure or did you?
I haven't done any
purchase it?
structural anything since I've been there. I've only owned I've worked there for 13 years. That was all done prior to me, and I've
So you
owned it.
purchased the building, this helps me in my questioning later.
Yes.
You purchased this building in the configuration it's in?
100%. I haven't
Okay.
touched anything.
All right.
I'm trying to fix the,
Yeah, that's all the questions I have.
okay.
Gentlemen, if you could stand to the side for just a minute.
Okay.
Is there anyone here that'd like to speak in favor or opposition to this variance request? Seeing none, final comments, gentlemen. Back to the microphone. Any final comments?
I'm good. I have nothing else.
Okay.
You?
You may be seated.
Thank you.
What is your pleasure?
I'd like to make a motion to approve the 3 variance requests as depicted on the survey.
We have a motion by Mr. McCann to approve the 3 variance requests as depicted on survey. Do we have a second?
A second.
We have a second by Ms. Mallard. Any discussion?
My only comment would be that if that road turned convex instead of concave as it does now, it might do a impact the sight line for the traffic, but it doesn't, and it looks as though the Sykes Creek Parkway coming out, it doesn't obstruct any sight lines there for the traffic either. So it looks good.
That was going to be my question for you, Mr. McCann. Did you go by the property?
I did, yes.
Do you see any issue? I mean, obviously that roof line's been there for a while, but it's different if you enclose it. Do you see any issues with being able to see oncoming traffic or anything of that nature?
No, I don't see any issues.
Okay. Any other comments or questions before I read the 6 points? All right. All right, these are the variance hardship worksheet points. I do have to read through those and give my opinion on those as we go through these, okay? Special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification. Probably the only special condition or circumstance that would exist that I can see is the configuration of the property. Because of the configuration of the property, it might be considered as a special condition or circumstance, whereas certain parts of the property would be closer to the property line than other parts, where if it was a rectangular property, it wouldn't be such. Special conditions and circumstances do not result of the actions of the applicant, and they do not. The granting of the variance will not confer on the applicant any special privilege as denied by the provisions of this chapter of the other lands, buildings, or structures in the identical zoning classification. We take each of these on a case-by-case basis. We do not give any special privileges to somebody. We do not know him. He's not a friend of the board, for example. So that's what that is dealing with. The little enforcement of the provisions of this chapter would deprive the applicant of the rights commonly enjoyed by the properties and identical zoning classification and the provisions of the chapter will constitute an unnecessary and undue hardship on the applicant. I don't think that if we said no, that it would deprive him of any rights enjoyed by any other applicant. He'd be able to continue to do his business. He just wouldn't be able to enclose that particular building. As far as it being an unnecessary and undue hardship, possibly. It could be considered as such because he would not be able to handle the heavier equipment that he's having to do so, because without that enclosure, he couldn't put that extra additional equipment in there that he needs to do. That the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. It is the minimum variance that would be required to be able to complete the structure that he's wanting to complete and legitimize what is already in existence. That the granting of the variance will be in harmony with general intent and purpose of this chapter, as such variance will not be injurious to the area involved, otherwise detrimental to public welfare. We've already asked the question of Mr. McCann if it would endanger the sight line, which would be the most important part about this. If somebody couldn't see oncoming traffic because you put that there, I would certainly be opposed. But Mr. McCann says it would not, so I don't see how it would be injurious to the area should it be approved. Okay? All right, we have a motion and a second to approve the variance as depicted on survey. All in favor say aye. Aye. Any opposed, say no. And your variance passes. Mr. Bodie, may we have the next applicant as requesting a variance?
Yes. Excuse me. Item number 2, variance application 23V00035, Thomas J. Narvo III and Cheryl Navo. Request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-1446, D3, to permit a variance to allow a swimming pool to be located forward of the front building line of the principal structure. And variance number 2, Section 62-1446, D7, to permit a variance to allow a screen enclosure to be located forward of the front building line of the principal structure in a PUD, planned unit development zoning classification, and this is located at tax account number 2601217 in District 4.
All right, please state your name and address for the record, sir.
Thomas J. Navo III, 1687 Frontier Drive, Melbourne, Florida.
Ma'am,
Cheryl Navo, 1687 Frontier Drive.
please both raise your right hands. Do you swear or affirm the evidence you're about to give us Board of Adjustments is the truth?
Yes.
Yes.
Okay,
My phone went off of my.
have to wait. All right, how may we help you all today?
We're requesting 2 variances to put a
Yes.
swimming pool in our front yard. Our yard does not have any room in the back. It's also sort of triangle shaped, and then the point goes to the back, and there's a golf course behind and a pond. So we can't do that. And we'd like to put one in the front with a courtyard around it, with a wall, swimming pool, and a bird cage over the top. That's our request.
Okay.
Do you need more? Should I read something? Sorry, this is my first time doing this.
You're in District 4, Dr.
Okay,
Bass.
District 4.
Please make sure to turn your mic.
You do. All right, I'm sorry. Oh. All right.
Take care of it.
You did say that you had two variance requests.
Yes.
I see on the drawing on page 22 that it shows the proposed pool and deck, but I was wondering, on your second request for the screen enclosure, where does that lie? Where is it placed?
On the top. So there's a 6-foot wall around it, the courtyard. The screen
Where was
itself
that?
just goes over the top.
Okay. Where is the 6-foot fence around the courtyard? Which courtyard?
Did you
I
get
guess
these
I'm-
plans that were included with it?
I'm looking at the drawing right now, is what I was looking at.
Yeah, it should be in these building plans showing the 6-foot wall with the cage on top of the wall. It's right around the exterior of the proposed pool
Page 36.
and deck area.
Oh, page 36, okay. All right. I drove around the community, and I was very impressed by the environment as a whole. The 15-mile-an-hour streets are narrow, 2-lane, tree-lined, most with curbs, then grass easement, and then a concrete sidewalk, as shown on page 19. I also noticed that service trucks block one lane of traffic on the streets. The streets are narrow, so when the service trucks are there, they cannot, because of the sidewalks, pull off. And I just noticed that part of one lane is always blocked in that case. At least when I was there, it was,
Okay.
from certain trucks. Right. And I also noticed that many people were using the sidewalks. They walked along them. It looked very nice. I liked it. But let's see. Let's go back and refer to page 19. If I can, yes, page 19. Most of the properties, as can be seen in this photo, are 15 feet apart on both sides. So I don't want to see it's zero lot line, but they're small yards. You have 7.5 feet on each side of your house. So that provides side yards of 7.5 feet, which is where you're looking into. I calculated that I also, as I drove around, I calculated that approximately 10% maybe of the homes there have pools, but they are all in the backyards. I didn't see any that were in the front.
There are, in the community, there are 4 or 5 with enclosed courtyards and pools in the front.
In the front?
In the entire community, yes, we're
All
not
right.
the only
Were those,
one.
all right. Then I missed it. All right. That's why I wanted to bring that up. All right. As shown on page 18, even though you are facing the one road, but your house is, and on the side where the pool is going to be enclosed, is on Continental Avenue. And Continental Avenue is the only north-south through street connecting the 2 community entrance and exits to Murrell Road.
I'm thinking about that.
Yes.
Continental Avenue, where we're located at, the entrance and exit is
Right.
further up the road
It's up on
by Old Glory.
yes, it's on Old Glory,
Yes.
but the road that connects to Old Glory is Continental.
Continental, yes.
And it is an immediate left turn to get out to the gate on Old
That
Glory.
is correct. We're at the end
Then at the
of,
other end of Continental is the exit gate, which can be used for all the people that live there to get to Murrell. There's another gate there on
yes,
that
ma'am,
side.
but it's not open. It's locked all the time.
Oh, okay.
Yes, ma'am.
Then there's only one exit.
There's another exit on the north side, on the upper half of IRCC, off of
Independence.
Vieira Drive, is that it?
Onto Vieira.
Onto Vieira Drive, on the upper half of IRCC.
So I was thinking, as I drove by, that there would be quite a bit of local traffic to get out on the Old Glory Road, going past your house, especially the one that's coming down where you're facing.
Yes, but that gate is not open. Where we're located, right behind us at the golf course, is the maintenance buildings. And they keep that gate on that side.
Correct, but I meant
Locked.
the main gate on
The
Old
main
Glory.
gate, yes, which is
Right.
about 2 or 3 blocks up.
Right, but it's the only other exit
It's the
off
only
that
other exit
Continental.
that they have open, that they leave open. It's that's where the
Correct.
gate goes at.
Okay.
And the other exit, which is unmanned, is on the north side of IRCC.
I'm just thinking of the traffic that goes by your corner, that corner on
Understand.
Continental Drive is what I'm thinking about when I'm asking you this. People have to at least exit one way on Old Glory, and that is at the end of Continental.
They have, our street, of course, is Pioneer, then, Frontier, then Pioneer, then Old Glory, I think,
Yeah.
right. And mostly the
But those,
vehicles that go in front of ours is the golf carts for maintenance.
And I'm sorry, Ms. Bass, I said page 36 a minute ago, I meant page 22. I flipped one too many documents.
oh, okay, well,
So on page 22, you can see the outline of the proposed pool and deck. And Mr. Bodie, just quick question. They're not needing any adjustments to the setback. They're within the setbacks on the property, am I correct?
Yes, they're within the setbacks, so they didn't have to apply for them.
Okay.
Okay. All right. Let me just see here. I was thinking about other people driving by
Yes,
your
ma'am.
property, looking into the pool area. So I was just thinking
Right.
about that.
The way that it's designed, they wouldn't be able to look into the pool area. In fact, that's something that's what the wall would be. So we'd have a wall around that courtyard.
Okay, good.
And the birdcage just on the very top.
That was what I was missing in the pictures, and anyway, all right, fine. And then you're within your 7.5 feet, all right? I did notice that you had 3 backyard patios that were in the PUD golf course easement. I
Are
just
they?
noticed that according
here.
to the
Oh,
drawing.
right.
Just- All right.
They're the type
I
that
can
can.
answer.
Okay, sorry.
That is correct. When we bought the home, we had the place remodeled, put in the patios with the directions that if they had to get under the patio for pipes or anything, that we would be responsible for assuming that cost.
Okay, all right. I think,
It's right there.
all right. I just want to just take a moment here and make sure I've covered all my comments. Very well. Does
good?
anybody else have questions?
We're getting that. All right. Mr. Huffman, you have any questions? No, sir. Mr. McCann? No. Ms. Mallard? No. And I have none. If you can just stand to the side for a moment. Is there anyone in the audience that'd like to speak in favor or opposition to this variance request? Seeing none, please come back to the podium. And let me just preface this. In the event that somebody does come to the podium and you're standing to the side, just have a seat. Everybody understand that? Okay. Any final comments for me?
No, we don't have any additional comments.
Okay. Thank you. You may be seated. What is the pleasure of the board?
Having answered my questions and my concerns, I'll make a motion to approve the variance as depicted by the survey.
We have a motion by Dr. Bass to approve the variance as depicted on survey. Do we have a second?
I'll second.
Ms. Mallard is seconded. Yes, my apologies. We have a motion to approve both variances
Correct.
as depicted on survey.
Yes.
I'll second.
Corrected?
variance.
Okay, thank you. Any comments or concerns, ladies and gentlemen? Then let's go through the points. Special conditions, circumstances exist which are not applicable to other lands, buildings, or structures in the identical zoning classification. I did want to ask, just stay where you are, just nod at me. Did you all build the home or did you buy it in existence? Okay, all right. The only thing that I see would be special circumstances beyond the design of the lot is the fact that it does back up directly to a golf course easement, which putting a pool in a golf course easement would not be wise. So in my opinion, that would be the conditions or circumstances that exist which would not be applicable to other lands maybe in that same area. That special conditions, circumstances do not result of the actions of the applicant. Again, they purchased the house. If I had read this, I wouldn't have had to ask the question. They purchased the house already in its configuration on the property, and so they didn't create the conditions that exist. That granting the variance request will not confer on the applicant any special privilege as denied by provisions of this chapter of the lands, buildings, or structures in the identical zoning classification. Again, we do not know them. We take each of these on a case-by-case basis. We are not granting any favoritism. They do not have superstar status. They're not Michael Jordan or somebody like that. So The literal enforcement of the provision of this chapter would deprive the applicant of rights commonly enjoyed by other properties in identical zoning classification. Other provisions of the chapter will constitute an unnecessary and undue hardship on the applicant. If we denied this, it would not deprive you of rights to be able to enjoy your land or use your land. It would deprive you of the right to be able to build a pool. But it would not take away your rights to enjoy your property as everyone else gets to enjoy their property. That the variance granted as the minimum variance shall make possible the reasonable use of the land, building, or structure. It is the minimum variance that would be required for them to build the pool that they're wanting to build. However, they already have a house on the property, so it would not, in that sense, be the minimum variance to make possible reasonable use of the land. It would just be the minimum variance required for the construction of this pool. That granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to public welfare. My understanding is the reason that pools are not desired to be in front of the house is for aesthetics primarily. As you're doing it with a wall, et cetera, I don't see that it would be out of line with the intent and purpose of the code, and I don't believe it's injurious to the area. You are within the setbacks, so you're not hampering any line of sight, any traffic movement of that nature. So that's the 6 points. We have a motion and a second to approve both variances as depicted on survey. All in favor say aye.
Aye.
Aye. Any opposed say no. And your variance passes. Mr. Bodie, may we have the next applicant that is requesting a variance?
Yes, application item number 3, variance application 23V00036, Kevin D. and Christine L. Hutchenson request variance of Chapter 62, Article 6, Brevard County Code, Section 62-2123A, to permit a variance of 2.4 feet from the required 5-foot side east setback for a swimming pool screen enclosure in a PUD, planned unit development zoning classification, and this is located at tax account number 26-03206 in District 4.
Very well. Hello, sir. Please state your name and address for the record.
Kevin Hutchenson, 627 Sugarwood Way, Melbourne.
Please raise your right hand. Do you swear or affirm the evidence you're about to give this Board of Adjustments is the truth?
I do.
And how may we help you?
We're here to maybe fix a problem that's been in the works for a while. My wife and I purchased this property on August the 1st of 95. The footprint of the pool and the house has not changed, but the northeast corner of the pool area is in the is in a zone of with an easement for the HOA property, and so we're requesting a variance to accept the build out as it is. We've made no changes to the footprint of the property, and we purchased it that way.
All right. Again, you're in District 4. Dr. Bass.
I have driven by the property, and I am familiar with Suntree, with its special covenants and restrictions, and as part of Suntree, we have sub-associations that have their own restrictions and covenants. Now, the first thing I was very pleased to see was that the variance proposed on Sugarwood has been approved by the president of the sub-association, which means all the covenants therein are approved or follow that area. The other thing I noticed is that it says that other lands or buildings, no other measures are impacted. And I would like to point out that we have a golf course that is privately owned, and it is very restrictive. And this property is not near the golf course at all. So there would be no impact whatsoever in that area, which is surrounding the Woodbridge area. Therefore, in looking at this, and with the approval of the sub-association, and knowing that Suntree or the golf course is not affected, and when I look at the houses, when I look at the photo from above, it actually is backing up into a grassland, not into another yard of a person's house in Woodbridge. Therefore, I have no further questions of Mr. Hutchenson.
Okay. Mr. McCann, you have any questions?
No.
Mr. Huffman?
No.
Ms. Mallard?
No.
You're just rebuilding the new enclosure in the exact same spot the old enclosure is, correct?
It was basically a repair job.
Okay.
We had some damage where the screen enclosure attached to the house. We had to repair that. It was cost effective to upgrade that screen enclosure, put it back on the same footprint. There's been no changes to the footprint on the ground.
And so you're basically just legitimizing the
That's
structure
correct.
that's already been there?
That's correct.
Okay. That's all the questions I have. If you can stand to the side for just a moment.
Yes, sir.
Is there anyone here in the audience that'd like to speak in favor or opposition to this variance request? Seeing none, any final comments, sir?
No final comments.
All right, you may have a seat.
Thank you.
Was the pleasure of the board?
I make a motion to approve the variance as depicted by the survey.
We have a motion to approve the variances that are requested as depicted by survey. Do we have a second?
A second.
Dr. Bass has made the motion. Ms. Mallard has seconded. Do we have any discussion? Here we go. Special conditions and circumstances exist where not applicable to other lands, buildings, or structures in the same identical zoning classification. The only special circumstances are that this was an existing structure that they inherited. They did not build this structure. They did not do it without permits and then come in here and say, help me. They're just trying to get a structure that is already in existence legitimized. That special conditions and circumstances do not result from the actions of the applicant. Again, this property was already there and already in place, so I do not see that there's any issues. No other areas are in, that the granting of this variance requested will not confer on the applicants any special privilege that is denied by the provisions of this chapter of the lands, buildings, or structures in identical zoning classification. Again, we take these on a case-by-case basis, so we're not giving any special privileges or rights, whichever way we go with this. The literal enforcement of the provision of this chapter would deprive the applicants of the rights commonly enjoyed by other properties in identical zoning classification. The provisions of this chapter will constitute an unnecessary and undue hardship on the applicant. It wouldn't deprive him of rights to be able to use the land. It would certainly create an unnecessary and undue hardship, as this is an existing structure and they would be required to move it if we did not approve this. That the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. It is a minimum variance that would be required to legitimize the enclosure that already exists. The granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved, otherwise detrimental to public welfare. I believe, since this structure already exists, that it would be in harmony with the chapter of this variance, and that it would not be harmful to the area involved. We have a motion and a second on the table. All in favor say aye.
Aye.
Aye. All opposed say no, and your variance passes. Mr. Bodie, may we have the next applicant requesting a variance?
Yes, item number 4, variance application 23V00037, Kerei Stampfel. Request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-1345B to permit a variance of 7.2 feet from the required 7.5 foot side east setback for an accessory structure. Variance number 2, Section 62-1345 5B to permit a variance of 5 feet from the required 5-foot minimum separation distance for an accessory structure in an RU-1-11 single-family residential zoning classification, and this is located at tax account number 2418525 in District 2.
The applicants, please come to the podium.
Good afternoon.
Please state your
Board
name and
Chair.
address for the
My
record.
name is John Campbell. I'm a professional land surveyor. I'm Ms. Stempel's expert because a lot of this deals with surveying
Okay.
questions.
Your address, please, sir.
Pardon me, sir?
Name and address.
Oh, Merritt Island, Florida, last 50 years.
John, can you move the microphone a little closer to you so we can? Capture what you're saying.
115 Alma Boulevard, Merritt Island, Florida.
Thank you very much. Ma'am, please go to the microphone. State
I'm
your name and
Kerei
address.
Stampfel, 410 Artemis Boulevard, Merritt Island, Florida.
All right. Please raise your right hands. Do you swear affirm the evidence you're about to give us, Board of Adjustments, is the truth?
Yes.
And please speak clearly into the microphone, and how may we help you?
Mr. Chairman, may I give you the exhibits to pass out that I'd like to use?
You may. Thank you, sir. You do understand you don't get these back, correct, sir?
That's perfectly all right. I have a extra copy also for the.
If you have an extra copy, if you could give
For
Mr.
Paul
Bunny,
and
please.
his group, yes, sir. Yes, sir. I'd like to, if I may, make an opening statement. If many of you remember, a couple of years ago, there was a vigilante that went through this area and code enforced anonymously. I think as many as 40. Paul can probably verify how many people that were in violation to the side setback requirements for this area of Merritt Island. Ms. Stempel built a cabana, probably an open bar. I'd be more inclined to say that it's more for liquid than for food. And it's a very attractive thing. She built it without the knowledge of knowing that she needed a permit. However, after the anonymous complaint was filed, she endeavored to come into compliance. She engaged myself to prepare a legal description and easement vacation for a portion of the easement that her cabana was in. Also, she went before the zoning, into the zoning department, and talked to, I believe it was George Ritchie, who was the examiner at that period. I understand George is retired by now. He sent Kerei up to talk to Amber Hawley concerning the vacation of the easement that the cabana was in. She went through the process of hiring, again, myself to do the necessary surveying, Randall Bird to do the necessary engineering on the structure. She filed a petition with the commission. The commission was very sympathetic in granting her the vacation of the easement. The vote was 5-0. At the time, I'd like to go through my exhibits now. Exhibit 1 is, I've got a note on there, is Kerei's house. There's a picture, a drone picture of her home, should be the first thing that shows up in that exhibit. And in there's also a picture of the cabana that's being shown.
Is that the blue roof, or is that?
On the blue roof, correct.
Blue roof, yes, sir. I'm going to give Kerei a chance to talk, but there's a lot of things that I know about as a factual witness, because I represented many of the people in this area, being a local Brevard County Merritt Island surveyor with all this anonymous complaints. A little background: the commission was very upset that these anonymous complaints were being filed as just mean-spirited, is the word that I would say. They were tired of dealing with all of this, and I think some motion was done. The commission was very sympathetic with what was going on. As a result of this mean-spirited person filing anonymous complaints, there has been a change. Now people have to face their adversaries in a thing and say, neighbor, what's bothering you? What's in your craw? What can we do to make it better? However, Kerei did not have that opportunity. It was anonymous, and she did speak to both of her neighbors on either side of her. We do have permission, we do have letters from the neighbors saying they have no objections to the cabana as it is built. My second group of stuff is we flew a drone across this area of Merritt Island, especially with the canals and the swimming pools in the back. And just a shotgun approach, picked out 5 or 6 houses in the immediate area that have cabanas, stairways, storage rooms, and other sundry things in their easements. Kerei's went through over $2,000 worth of expenses, including the vacation of the easement. At the commission meeting, she was told that she met the conditions of the code enforcement issues, and part of that is in my other exhibit that's there. It's got the minutes of the commission meetings. And Kerei, I was not at that particular meeting, and I'll let Kerei tell you what happened there. Kerei, can you kind of advise the board and explain where you were and what went on before the board?
Yeah, pretty much like the minutes, state. They asked me, why I built a structure without a permit. I went down with a picture. I own another home that I was pulling a permit for. I showed them the picture off of Pinterest and said, this is going to go over a rolling barbecue. And she said, no, you don't need a permit for that. It did not occur to me that I was in an easement. That was totally on me. But the second that I was violated, I went immediately down and pulled a permit, hired an engineer, hired a survey, did everything that was necessary, went to the vacation hearing, which they granted it only because they spoke to my neighbor who is here and to her partner that was also at the house at the time that one of the commissioners came and spoke to them. And they both said they didn't have an issue with it. And he spoke to my neighbor on the other side who said that he didn't have an issue with it, and that I was very careful not to block anybody's view and make sure that this was a pleasant structure.
Okay.
Move
the microphone back to you, please.
Let me just follow up with a couple of other items on this thing. As far as could it be put any other place, there was an existing wooden deck there. There is a canal behind her house. There are setbacks to the back rear of the lot. And of course, it's adjacent to her swimming pool. Obviously, she wouldn't want to put it in her front yard, which is not fair, not necessarily going to be the best place to have a cabana. And there were a lot of circumstances that, she's complied with making a first mistake. The first mistake was not getting a permit. She's done everything that she had to do, including a second anonymous complaint that was filed against her because we needed a variance, which was not explained by Mr. Ritchie when Kerei came and spoke to the zoning department.
It was my understanding at that time. It was my understanding, and it is even in the minutes of the vacation of easement hearing, that it literally said this satisfied the requirements of the code violation. So I thought I was done, and the only person who has ever told me that I had to have this variance was the code officer. A couple months after, and I have the email that he sent me, he said, I'm noticing that you have not filed a variance. I thought he was maybe a misspell and thought he meant the vacation. So the email I sent him back was, oh, we got the vacation, everything's wonderful, that my permit should be going through. And he sent me another email and said, no, you have to apply for this variance. And that was the first time that I found out about it. I tried for a few months with Mr. Ritchie to figure out how to word the application myself, and it became apparent to me that it is very specific and I needed some help. So I hired Mr. Campbell again to help me with the variance since he helped me through the vacation.
Okay. Anything else?
One thing that it does say in here, that it's,
Yeah, well, the last items are the surveys.
Move the
and
microphone back to
engineering.
your.
Oh, I'm sorry. The last two exhibits are the surveys that she had to go through and the engineer that had to approve that the structure she built met the building code. So I think she's done everything she's had to do. Sadly, she got some bad advice. Sadly, she made a mistake. But here we've got a beautiful cabana sitting in an area that's suitable for where it's be, with neighbors that have the same benefit of having their backyard, their recreation, their pools being used. And it's not our position here to go and rat on all these other folks that are in violation. The county is reactive, not proactive, which means that unless somebody complains, generally a code enforcement issue is not issued. We don't have Big Brother in this county running around watching everything that we do. I'd like you to respectfully approve this request. I think there's plenty of special conditions that caused it to happen and related it to it. The roof area is open. There is full use of the easement if it needed to go through. The wood underneath the easement is, underneath the cabana is slotted so that drainage can go through it or under it. The neighbor that lives exact next door to us has no objections. And I believe she'll be here to support us if necessarily. No, I don't think we meet all 6 things that Mr. Chairman, that you're talking about, but I think in all fairness, and fairness is something that needs to be considered too, that she should be denied what so many other people in the neighborhood do have, as witnessed by the drone photographs that we've flown.
All right. You are in District 2, Mr. McCann.
You're asking for the approval of 2 variances. The first one is because the structure is built very close to the side yard.
yes.
And that's, you're requesting a 7.2-foot variance from a 7.5-foot setback. And then the other one is because the structure actually attaches to the primary residence.
It doesn't actually attach to the primary residence.
Just touches.
There's a pole there, and as my guy was doing it and putting the block on there, I said, is there any way that we could put some block over here so that it looks like this is part of this? It's in the engineering, you can see that it's totally separate, and it is not attached to the structure in any way.
It's being
And
too
that's
close.
that's just a faux little thing that he built to make it look smooth.
It butts up against it, though.
It is up against it. Well, it's about, I think there's about 4 inches.
Okay.
Is that your porch?
And
So-
that's not actually the house, that's my porch
Okay.
or floor.
Well, the
room.
primary structure. So I would be concerned with a few things, and I think that's why the code exists. One would be access for emergency personnel to get from the front yard to the backyard or any other safety reasons. But this particular structure is basically an open structure.
Correct.
And you have access there's no wall there.
No.
It's sort of like a breezeway.
It's
You-
exactly
You have
like that.
access. And then the only, I would be concerned about the obstruction of views, especially on a canal, but it looks like only your view would be obstructed, if any, and neither one of your adjacent neighbors. Is that right?
That's correct. It was one of my biggest concerns, not to block anybody's view.
Okay. That's it. Thank you.
All right, Ms. Mallard.
No questions.
Mr. Huffman?
Yes. I'm looking at this picture,
Yes, sir.
and you say it's an open structure,
Yes.
but related to the EMT question, I don't think it could get a gurney through there. It looks like there's a,
Well, everything here is movable.
Okay, you can't talk English in front of the microphone.
I'm sorry. I was going to
so you say those are mobile pieces?
Those are mobile pieces. That's correct, sir.
So they could be moved out of the
They
way in
could
an
be
emergency?
moved, but there is quite a distance there. I'd probably say it's not, I
I'm
mean,
only
it's-
looking end on to the,
Point the
and
microphone towards you.
I'm sorry. And I have a bunch of coolers and stuff that are sitting there,
So-
kind of thing.
this solid counter or whatever that's moved, how far away is that from the wall of the house?
Oh, that's a good question, but I know it's on
I
the
don't want
engineering
inches.
drawing. I'd
It-
say, it's feet. It's
It's
feet.
on the survey, sir.
Yeah, it's feet. It's not on the survey, but it is on the engineering drawing as what the distance is from that to the
Telling me it's
house.
6 feet? 5
It's 6
feet?
feet. I'd say, I'm terrible at measurements.
That's okay.
I would
Just-
say
is
that's
it-
10 feet.
Could you
so-
lay down between it? Is that 5, 6 feet?
Probably not me. Probably cut my head off.
All right, so it's 4 feet.
Okay.
All right, they can get a gurney through 4 feet.
Okay.
Okay, and I notice on the other side, there's a fence
Yes.
around so they couldn't come through there.
Well, there's a gate.
There is a
From the front
gate.
yard, there's a gate.
Okay,
Yes.
thank you.
Dr. Bass?
Just a comment. This is a county consideration with written stated requirements. I cannot base an evaluation on similar area violations. Can't do that.
Yes, ma'am.
I also cannot base an evaluation on past conversations of what others have accomplished, not accomplished, said to you. I can't make a judgment on that at all. All I can do is evaluate this based upon the picture that you've given us and the requirements of the county.
I do have with me also where I have pulled a permit for everything I've ever done on that home. I have that whole list of permits to show that I'm, not the kind of
I
person who
don't need
just.
those permits. I just
understand.
want to know about the variance. And what's been done in the past is not up for consideration here. That's all in my comments.
If you have all these other permits, why not a permit on this one before you build it?
I went down to the county. I was pulling a permit for another house that I own, and I had a picture of what I was going to build, and I showed it to the girl who was processing, taking me in, and said, I'm about to put this in. I bought this rolling barbecue grill from Lowe's, and I'm going to, build this over it. Do I need a permit? And she said, oh, not for that, or else I would have pulled a permit. That's what I was there for.
Okay.
But
You've pulled multiple permits.
Yes.
So permits are required to build something.
Correct. In my mind, though, and I guess there's no excuse.
Okay.
I was thinking I was just building a little roof over the top of
I've
my
got some
little
more questions for
rolling.
you in just a minute, but let
Okay.
me ask Mr. Bodie a question. Is this one of those cases where they attached it to the house that it would solve that 1 5-foot issue?
No. I think that it's still an accessory structure. If you look at the pictures, it's
Okay.
actually a foot or two above the roof of the house.
Yes, it is.
And goes over top of it.
Right.
So,
I
don't-
just
I
know
don't
we've
know
had
how you
we've had
would-
some situations, as you know, that
yeah, I don't know.
where
how
where
you
if they
would-
just attached it, it
Yeah,
solved
it's
the
supposed to
issue,
be attached with a similar roof, made out of the same stuff.
and it's not.
If it was a tile roof, it had to have
Okay.
tile, it had to meet
Okay.
all the architecturally the same.
Okay, thank you. Part of what we do here, and the reason for my question to him is if we can find solutions, we find them, okay? There's been cases where somebody's built something and all they really needed to do was attach it to the house and it takes away all the problems. This, and even at that, would not take away all the problems because you have the setback issue of needing all but 3 inches of that side setback. You mentioned the vacation of the easement, and you thought that dealt with everything. Obviously, what you were dealing with in that case was just that singular violation. It did not mean that there were not other violations, which, again, if a permit would have been pulled, you'd have found out
I have a
that, that
permit.
you.
I pulled a permit.
Well, not before you built this thing.
Correct. I
Okay.
apologize.
So if you had pulled a permit to build it, you would have known that you had issues there.
Correct.
And I'm going to back up something Dr. Bass said just a minute ago. Other violations does not give us a right to have a violation, okay?
I understand.
If that was the case, everybody that ran a red light gave me the right to run a red light, and we'd have a disaster if we, has anybody ever been there when 6 cars went through the red light because the guy in front of them did? And that's a disaster waiting to happen. And so just because you drive around and say, oh, well, there's 6 other people that violated, so it's okay for me to, is not the case. I'm supposed to be asking questions right now, but I'm just going to make a statement to you. My biggest issue that I have 3 issues. Number 1 is the amount of the variances that are required. You're within 3 inches on one and you're 0 on the other. To me, that's an issue, okay? The second biggest issue that I have is the fact that a permit was not pulled, and you're knowledgeable. You know permits are required to build something. If you're just looking at me and saying, hey, I talked to a contractor, the contractor said I didn't need it, so he built it. That gives, and we've had those. And we look at it a little bit differently, but even some of those we've denied them because the homeowner still has a responsibility to make sure the contractor's telling them the right thing, okay? We have so many cases that come before us where people build stuff, and in many of the cases, I don't want to say most because I could be wrong, but in many of the cases, they know what they're doing is not right. And then they get caught, and they, as you say, it's a reactive thing. Somebody complains and they
Sir, I went down there to pull a permit, though. I was standing there right in the office. I pulled a permit on that day for another house. I literally asked them if I needed a permit, or else I would have pulled a permit. I was in the office to pull a permit. It's not like I was purposefully trying to deceive somebody or
Okay.
get away with something.
Are you able, I don't know if you're able to speak to that or not, but I'm going to ask you to if you can. That she was there, she showed them a picture of what she wanted to build, and they said it was okay, she didn't need a permit. Are you
I'm not real sure. I can't answer on that, but I could have given her the wrong advice or something. Maybe the tech didn't understand exactly what she was building.
Mm-hmm.
Maybe they thought she was just putting in something that was less than 100 square feet that didn't need a permit.
Okay. Did you tell them how big it was going to be?
No, I did not.
Okay. So if it's less than 100 square feet, it does not need a permit?
If you're putting up an accessory structure less than 100 square feet that is not on concrete, it does not need to have a building permit. However, it does need to meet all the zoning setback requirements.
Okay.
If it is on concrete and less than 100 square feet, it needs a permit. You still need to meet all the zoning setback requirements, though.
This is more of a curiosity question. I'm not trying to put you on the hot seat. Please forgive me if it feels that way. I'm not.
No, that would burn my butt.
What is someone to do if they come to your office and say, do I need a permit? And they're told they don't, and then later they found out they did. What's someone to do in that situation? Was there another step she could have taken to assure?
You'd have to probably have it in writing.
Okay, so she should have just looked at him and said, well, if I don't need, would you give me something in writing saying I don't need that permit?
She could have asked for that, yes.
Okay, so that would have been, and this is more educational than anything at this point. So that would have been the second step that she probably should have taken at that point.
Or she could have talked to maybe one of the plans examiners instead of one of the techs, or some of the zoning people instead of the tech up front.
Who
Probably
was it
should have
that
asked to speak to
I
one of the.
honestly do not recall.
Well, I'm not asking for a name. Were they just somebody at the front desk?
Yes, it was somebody who processed me in.
Okay. So you did not talk to, and just move the microphone to your direction?
No, I didn't.
You did not talk to any of the planners, any of the zoning folks? You just talked to whoever was at the desk?
Not the
So-
front desk when you go in, but, where there's, 3 or 4 seats and they, take your paperwork. And since I was there and I knew I was wanting to do this, since I
Okay.
just bought the barbecue, I asked her.
And who would that be that she was talking to then?
I would not know. It was one of the techs.
Well, I'm
that-
not saying a person.
One of the building techs that takes in building applications. It
Okay.
sounds like who she was talking.
So they're not knowledgeable in what needs to be done. They just take paperwork and process it.
That's correct.
Okay. All right. You wanted to say something? Yeah, go ahead.
It is true. It is true that when the easement became a problem, George sent her up to talk to Amber, and Amber gave her the kit to vacate the easement, and
Correct.
no one else told her that the setback, you can have, if there was no roof on that building, she could have exactly what she has.
Right, but understanding,
Yeah, but I.
when she went up to deal with what she's did, she was dealing with the easement, the fact that she'd built in an easement. That's what she was dealing with. They weren't talking about codes at that point. They were just talking about that
If you
easement.
look at what the commission said in their minutes that this satisfies the code enforcement issue.
Right, but the code enforcement issue was not the building or the setbacks. The code enforcement issue was the fact that she built inside an easement.
That's true.
So they were just dealing with the easement. They were not dealing with anything else. So she did satisfy that violation, but that didn't mean there were not others.
Nobody had ever informed me that there was another one. It wasn't until after the vacation of the easement,
Okay.
and I thought I was finished, that I found out about this.
All right.
Yeah,
That's all the questions I have. I am going to ask you to stand to the
I
side.
have a question.
Oh, wait, I'm sorry. Mr. Huffman. Or, I'm sorry, Mr. McCann.
This is for Mr. Campbell. You did the survey.
yes, sir.
On the survey, and I can't read it, my eyes are terrible, is there a measurement of the cabana structure?
There is a copy of my survey in the package, and my survey showed that it was a covered structure that was
Yeah.
there. The word
It shows
covered-
that the
word
covered
covered-
area is 8.6 by 14.8.
Yep, that's correct.
Which would be a little over 100 square feet.
Yes.
Okay, and the reason I asked is real close to not even needing a permit. However, we still have to adhere to the code and the setbacks, but we're spending a lot of time on whether or not you got a permit, and you're close to not needing one. And I don't have questions, but I'm gonna reserve my comments for when we have our discussion.
May I? May I? When a client, when a citizen goes up to the zoning department, talks to zoning officials, and then is told that she should know what the zoning requirements are, doesn't that sound unfair? Shouldn't the zoning officials have told her? There's no denial that she wasn't told. Everybody knows she wasn't told.
I don't disagree with you, but I always go in when I'm doing something and ask for one of the planners or one of the zoning officials.
speak with
I
George
never
Ritchie.
talk to.
George Ritchie is
I
a zoning
spoke to George
official.
Ritchie. I emailed back
But
and
that
forth with him
was,
for 6
that
months.
was in regards to.
No, that was in regards to the variance.
Right.
But that was only after, I found out from Rick May, the code enforcement officer, that I needed one. But I had spoken to Mr. Ritchie before on the variance. He's the one who gave me to Amber Hawley. And never one time did anybody mention to me that I also needed a variance with
But
it.
you were speaking with him about the violation that you currently had, am I correct?
Yes, sir, you are
Okay.
correct.
So again, he's going to address that violation.
But don't
He's
you
not
think
going to,
he
he's
should
not going to
have
bring up
told me
other violations because, as you correctly stated, They're reactive, not proactive, okay? So he's not bringing up other violations.
Wouldn't he have known that once they vacated the easement that I was going to have a variance? Shouldn't somebody have warned me or told me or, something? I mean, he had to know.
I don't know the answer to that. You're asking.
I really don't think this is comparable of 6 people running a red light, because everybody knows you shouldn't have run the red light to begin with.
Well,
Kerei
your
was-
statement was there's other people that built that are outside code.
that
Just
she-
because they build outside code, and they may have known they were building outside code, okay? We don't know if they did or not. We just assume they probably did. Doesn't give you a right to build with outside code. That's whether you talk about a red light or robbing a bank. If you know not to do it, you don't do it.
Well, somehow I feel like I'm about ready to fall on my sword. But I respectfully disagree with you, sir.
You are more than welcome to do that, and you won't be the first and the last. If you can stand to the side for just a minute, please. Do you live to the side where the cabana is built? I do. Then would you please come to the podium?
Yeah, I mean, I'm.
Please state your name and address.
Colleen
for the-
Mitchell. I'm at 420 Artemis Boulevard.
Raise your right hand. Do you swear or affirm the evidence you're about to give us Board of Adjustments is the truth?
I do.
Here's my question for you. You live to the side that's most affected, okay? And I'm not sure that it does. From the picture, it looks like it kind of overhangs the fence, and I don't know that it does, but I'm just saying it from the
No,
picture.
it's close to the fence, but it doesn't overhang.
Okay, so it's 3 inches from the fence, according to the variance that you need.
Correct.
How do you feel about that cabana being built that close to
I
your fence?
can't even see it. I have a shed that's close by too, and the cabana is a little bit past the shed. It doesn't obstruct anything at all for me. It doesn't bother me one bit, because it is further back. Like, I still have a view all the way down the canal, so it doesn't obstruct anything for me.
Okay. Anybody else have a question for her? That was what I want, the reason I brought you up, that's what I want to know. You're the one most affected by this.
Correct.
Because it's on your side of the property.
Correct.
If you have an issue with it, I certainly have an issue with it.
I have zero issue with it at all.
Okay. All right, thank you.
You're welcome.
Is there anyone else that'd like to speak in favor or opposition to this variance request? Forgive me, I needed to ask a question I didn't ask. Come back.
Yes.
Are you in favor or opposition?
In favor.
Okay, thank you. I have to ask that question, I forgot. I'm sorry. I apologize for making you run back, I did. Nobody else is here? Final comments from either of you? You may be seated. Let's start with what's your pleasure, board?
I'd like to make a motion to approve both variance requests as depicted in the survey.
We have a motion to approve both variance requests as depicted on survey. Do we have a second?
A second.
Ms. Mallard is seconded. Now we are ready for discussion, sir.
Thank you. So,
Don't hurt me.
I do want to, no, I appreciate it. I do want to make some quick housekeeping comments, which regards this, but also regards one of the variance requests we had at the last meeting, which I believe we got it wrong as a group, but that's my opinion, not everyone's opinion. But in that particular request, as the district representative for that district, I feel like it's been protocol that I speak first.
Yes, sir.
And in that situation, I was not afforded that opportunity, and I think it set the tone for opposition when I don't believe that was a variance request that was unreasonable at all. And I just want to make the statement, thank you for allowing me to speak first and doing it in the proper order this time, because I can see this one's a little bit controversial for some of the members. Maybe I'm wrong, it's just how I'm reading it, but I'd like to say a few things. I did visit the property like I did in the last one. Extremely comfortable with this request. That breezeway, I mean, it's not really a structure, it's a roof structure on columns that are built on top of a wood deck and a barbecue grill that's looks sort of like a bar area, but it's movable. You got a sufficient breezeway for ingress and egress. It's not exactly attached to the building, it butts up to it. And it doesn't affect the neighbor's view, it doesn't affect anything, it doesn't have any negative impact on the community or anyone, and we're getting caught up a lot on whether or not she pulled a permit. I believe this applicant showed that she is one who does pull permits. She does comply with the permit process. She's done it before. She actually attempted to do it in this one and was advised poorly that she didn't need one. It's one of those situations where it's very close to not even needing a permit. Now, I'm not saying that you were completely in the right because it was built, within the setbacks. Had a permit been pulled, then it would have been built right and we wouldn't have this issue. So we do have that problem. But I don't feel like there was anything malicious. I don't think you were trying to circumvent anything. I think you were trying to build yourself a nice little barbecue area that you're going to enjoy by your pool that doesn't affect anyone. And I've been to your property. I'm the district representative. You're in my district. And I fully 100% support your variance request.
Ms. Mallett? Ms. Bass?
Yes. I want to make a point that one point is that if your neighbor moves and we have a new neighbor that comes in, if they're going to be as graceful about this issue as your neighbor currently is. And I do want to re-verify what I said is I can't judge past conversations as a consideration for this request. Whether it's a stoplight or whatever example you want, anybody wants to use, I don't know about what he said and she said. I only know what the requirements are and what this request entails.
Mr. Hopman?
There are many ways in which these violations, adjustments, whatever, come before us. Simple inspection or whatever. I'm not moved by the argument about vigilantism, going around the neighborhood looking for these. That's one. Second, if we have a neighbor that's proactively supporting this, if they go to sell their own property, they've already accepted the fact that if this cabana is a detriment, they've already accepted the reduction in value of their property based on, and they have no recourse once this application, if it's approved, is approved. So I'm less concerned about future neighbors because the action is happening now. I'm reluctantly accepting of the fact that the EMTs can get back in there. I'm sure that that's a once in a lifetime or two emergency, and the people will be able to work that out.
First of all, if I didn't call you first, I apologize.
No, it was not your doing.
But still, I'm the one in control, and I should have. And until you just now said it, I didn't realize I didn't actually just look back at the minutes to see what happened. So I deeply apologize for that, and I will state to you, I also, though I was the deciding vote, think I did the wrong thing.
I think you did too.
Sometimes we don't get it right, and we would try hard. And I actually have thought about that one a long time, and if we had the ability to go back and say, hey, I changed my vote, I would do that, but I don't think the attorney's going to tell me I can do that. She just looked at me. I don't know if that was a look about shut up and go away or what, but anyway. But let's deal with the situation we've got here. I'm about to go through the 6 points, but I'm just going to give you opinion, okay? Which is what we do. We take a look at these and we go, what is best for the applicant? What's best for the neighborhood? And most importantly, we go, what's best for the neighborhood? What's best for code? There's a reason codes are in place. The reason there should be a separation is if there was a fire, that separation creates a fire break. In this case, it's a roof is basically what it is. If it catches fire, your house is going to catch fire. If your house catches fire, that's going to catch fire because there's no separation between the two. And that's really what the danger of that is. However, if I'm understanding correct, and you can correct me if I'm wrong with the statement I'm about to make, if you were 28 feet less, it doesn't matter. Am I correct?
28 feet, what do you mean?
Well, it's 127 feet is the size of this structure. So she is at 99 feet instead of 128 feet. She could have that thing sitting there and it doesn't matter?
No, it would matter.
It
Even
would.
though you don't have to get a building permit, you're exempt from a building permit, accessory structures still had to meet the setbacks.
That's what I needed to know. Okay. I think you thought you were doing the right thing. I think you asked somebody in the planning department, do I need a permit? They said no. Okay. That probably dissuades my biggest issue is people building without permits that know they're supposed to have a permit. Okay. I do have a problem where we're basically eliminating an entire 5-foot section. The 5-foot setback is being totally eliminated. How wide was that from front to back, going toward the house? I'm asking you, he gave you the...
From the
fence to the house.
I think we just, the surveyor, 8.6 feet.
Okay. So the 5 feet would have to come off this way. If they were to be 5 feet from the house,
They'd have to, yeah.
it would
so-
have to come toward the pool.
Right, so you need about, I guess, estimate of a couple feet,
So then the length of it is how far?
14.8.
So it would make it a 9-foot cabana instead of a 14-foot cabana, right? If they took care of the 5 foot.
Right.
Okay. I'm just asking. Don't look at me in that tone. Because I'm asking the question, I'm going to bring you back. Okay, go ahead.
There is actually a 5-foot opening from where it, not actually attaches, but where it starts next to my Florida room to where it is the next post. There's a 5-foot opening there.
Right.
So from there to there is 5 feet.
But there's still no 5 feet gap between your building and the house.
There is if we call that post, part of the building, then there's actually 5 feet opening.
Well, you'd have to take the roof off for 5 feet.
Oh, you mean the roof is considered part of it as well? Okay, I see. Now, just because I'm just desperate here, I'm just going to throw this out there. That is actually not part of the original structure. That is actually just a metal framed Florida room where that sits. My actual main structure is about 12 feet from there. That doesn't help.
No.
I'm just trying. Anything I can.
Now, it's part of your structure.
Okay.
Yeah.
I would jump up and down and do a backflip if it would help, I'm just thinking of
The code requires it to have a 5-foot separation from any other structure. So
Any
if
other
you had 2 sheds there side by side, you wouldn't meet that 5-foot separation.
Okay.
I'm going to ask a really bad question.
Go right ahead.
It's a bad question. I know before I ask. Would you be willing to take that 5 feet off?
Unfortunately, I could not because if I did, then everything would be right up against the house, and there wouldn't be any way for us to walk in between. You know, I kind
No,
of sit
because
there
it
and
would
barbecue.
come off toward the pool. Okay,
You
there
mean
has to be a
coming this-
5-foot
you mean
separation
coming
from the
this
house.
way,
If you took 5 feet of that off going toward the pool, that still
Yeah.
leaves you 9 feet of cabana.
Yeah.
And I don't know what the setback is on the other side, whether you could add that onto the other side
Yeah,
of it or
unfortunately, we
not.
could not, because then we'd be running into the pool.
Okay,
I
And the
think that
only
they only
reason I made it
vacated
that size
exactly
is-
where it's at anyway.
exactly where it is,
So-
okay. So I'm just asking if you'd be interested in taking 5 feet off of it and eliminate that.
I wish I could, just to resolve all of this. Unfortunately, the pieces that I bought are 14 feet that make my little area where I, cook.
Okay. I'm just asking.
Okay, yeah. Yeah, like you said, it's horrible. Go ahead.
Go ahead.
Consult my client a second.
Yeah.
You take 5 feet off your Florida room.
No, no.
No, that's
Yeah, no.
expensive.
Yeah, no.
I'm not even suggesting that.
No.
I was just saying, if she could take 5 feet of that roof off, then that resolves what, in my mind, is the biggest issue, is the fact that you're not having any separation between the house and that structure. So that's the reason I was asking that question. Thank you guys very much. Appreciate you
Thank you,
coming back
sir.
up for that. Let me, did I hear somebody start to say something?
I'd like to.
Go ahead.
Okay. I just want to make some more comments before we go into the 6 hardship criterias. We did talk about briefly, I think my 2 colleagues at the end talked about potential future neighbors in your neighbor's house and how it would impact them. But if I recall your testimony, ma'am, you stated that the structure, it doesn't affect your view at all, and it doesn't impact your home, your enjoyment of your property at all. So I'm just going to assume that your future neighbors are going to feel that it's not going to affect their view and their enjoyment of their property as well. And I also just want to add, I know we talk about we can't judge past conversations or what's happened in the past, but I think we have to listen to the testimony of each applicant, each person in support, each expert, each representative, and each person in opposition to get a full picture and hear all the testimony and look at all the evidence to make an informed decision. So to me, past conversations are important. It's facts, and the facts are important, and I will consider them. I want to emphasize again, we're making decisions up here that significantly impact people's lives and their use and enjoyment of their property. I want everyone to remember that when they're making their decisions, because as you can see by the emotions of this applicant, the last applicant may not have shown those type of emotions, but I know they feel it, and this is us deciding whether or not they get to use their property in a way that they want to use their property or should use their property, as long as it's within reason and doesn't negatively impact anything. I'll just leave it at that. And I don't see in this situation how this negatively impacts anything. A mistake was made, but it was an honest mistake, and it would break my heart to tell her she needs to take her structure down. It makes no sense.
Well, she wouldn't have to take it down. She'd have to take 5 feet of it off in order to comply.
I don't think you can do that.
Okay. Can I ask you a question?
Yes.
Okay. And I'm just covering what's in my head here, and not telling you which way I'm voting at this point. She's using a barbecue grill under there.
Yes.
Okay. There's no separation from the house. So the risk of that catching fire and then spreading to the house are greater, which is the purpose of that 5-foot separation. Do you see that as an issue or no?
I can't, I'm not an expert, but I barbecue in an enclosed patio that has screening. It has a roof, it has screening around it. So this one doesn't even have screening. It's out more in the open with more ventilation. I have a Florida room it's a screened-in room. It's a screened-in enclosure, and So, I mean, you're just asking me an opinion. I don't see how that increases any kind of fire dangers.
Okay. And I'm just so you know, I'm just bringing up the point that, you know, the reason that that 5 foot is there is for that particular cause, for that particular reason. Without that, there is that potential that if something happened there, it could spread easily and quickly to the house, and then, you know, the house is in trouble. That's the whole function and purpose of that 5 foot separation. But in your mind, you don't see that as an issue with this particular structure?
I honestly don't. I mean, we could say that the Florida room doesn't have a 5 foot separation either, and you can barbecue in the Florida room. No, I don't. I think more and as Mr. Huffman stated, I believe it's more of having the distance be for safety reasons to get emergency personnel in and out of the property if need be.
Okay. I don't generally ask this, but Mr. Bo, do you have anything to add to what we're talking about at this point?
No, I sure don't.
Okay, sir. Let me do the 6 points. Are we ready? Special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification. In my opinion, there are no special circumstances or conditions that exist that are different than what everybody else has in that area. That the special conditions and circumstances do not result of the actions of the applicant. Since there are no special circumstances or conditions, then it wouldn't result from the actions of the applicant, but it is the applicant that built the structure. Granting of the variance will not confer on the applicant any special privilege as denied by the provisions of this chapter. The other lands, buildings, or structures in identical zoning classification. We would not, if we approve this, be giving them any special privileges that we, as Mr. McCann accurately stated, we take each situation on a case-by-case basis and try to evaluate each one, and each one is different. Each one does have special nuances to it. So we would not be granting any special privileges here. That the literal enforcement of the provision of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification on the provisions of this chapter constitute an unnecessary and undue hardship on the applicant. If we denied your variance, I don't think it would create an undue hardship, and I don't think you would not be able to enjoy your property. You just would not have a 128 square foot accessory structure. I know there's more, or was that it? Hang on. I'm missing 2 for some reason off of that page. I'll find one of the others. Hang tight. Number 5, that the variance granted as the minimum variance will make possible the reasonable use of the land, building, or structure would be the minimum variance required for what was constructed. That granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. That is the question that I'm weighing in my mind at this point. Is it in harmony with the general intent and purpose of this chapter? No. Is it potentially hazardous and detrimental to public welfare? Because the reason for that is to have that 5 foot separation, it could be. But as Mr. McCann pointed out, he barbecues in his screen room, which is probably a great deal more dangerous than using an outside overhang. But if I'm answering that question correctly, in my mind, it could be a hazard to the public welfare, and if in fact the fire caught and spread to the house and so forth. All right. Any other discussions? I have a motion and a second to approve the variances as depicted on survey. Can we do it as a roll call? We can. We've been asked to do this as a roll call, so Ms. Mallard, yes or no?
Yes.
Mr. McCann, yes or no?
Yes.
Mr. Thomas, yes or no? Oh, I'm sorry, Ms. Bass, yes or no? No. Mr. Huffman, yes or no?
Yes.
Then it doesn't matter what I say. But I'm going to tell you a yes. And I'm going to tell you why I'm giving you a yes. I'm giving you a yes because your representative believes that it is right to do so, and I want to side with your representative. He's the one that represents you. In my opinion, he has the best view of it, and that's who I'm siding with, okay? If he had said no, I promise you, sitting here before you, I'd have said no, okay? Your variance passes. Thank you. We have no other cases before us. This meeting is adjourned.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.